Hey guys, John Wiehn, attorney and legal instructor for Blue to Gold Law Enforcement Training, coming to you today with another Roadside Chat. Today's question comes from an officer in Nevada, and the question is, which Fourth Amendment exception allows a school police officer to search a juvenile on campus based on an anonymous tip that the juvenile has a gun? Which recognized exception allows an officer to search a student for a gun after someone has said that the student has a gun? All right, so we're dealing with a lot of different things here. Let's walk through it. First off, the question is the tip truly anonymous? In this day and age, right, people call in on cell phones. Okay? Can that be tracked back to a subscriber, or is this a situation where the caller is using a burner phone or is using voice over internet, or somebody else tells somebody who tells somebody, right? And we can't find that originally reporting party. Okay, if the person is an anonymous reporting party, then the controlling case is going to be Florida versus JL. And in Florida versus JL, a anonymous person called in and said, hey, there's a subject at a bus stop wearing a plaid shirt and he's got a gun. He's carrying a weapon illegally. Officers responded, and without any kind of independent corroboration, they frisked him, they found a gun. The court said this kind of bare bones tip was insufficient to constitute reasonable suspicion. And Terry v. Ohio tells us if we're going to frisk somebody, we need specific articulable facts to believe that the person is armed and dangerous, more than a mere hunch. And in Florida versus jail, the court said that they did not have that. Just that bare bones, there's a guy at a bus stop wearing a plaid shirt, he's got a gun, is not a basis to frisk somebody. Now, I want you to compare that case to an Arizona case called In Re Roy L. And in that case, an SRO received a call that a subject on the quad, provided description, had a firearm, right? Officer went out, he observed the subject. The subject was wearing baggy clothes, which based on the officer's background training and experience, he knew people wear baggy clothes when they're carrying firearms to prevent bulging, prevent imprinting, right? He saw the subject saw him, and the subject immediately began evading him, right? He engaged in evasive maneuvers, he bladed away from him, his hand hovered over his waistband. Now, in that case, the Arizona Supreme Court said that that was sufficient basis to constitute reasonable suspicion, all right? So, change the facts, change the answer, right? We've got independent corroboration in Re Roy L. versus Florida v. JL. There was no independent corroboration, okay? Now, in addition, when we're talking about SROs, things get a little bit more difficult, okay? Safford Unified School District number 1 versus Reading is a United States Supreme Court case. And in that case, it says if a school official is performing the search, then there only needs to be a moderate chance of finding evidence. Okay? New Jersey versus TLO is another United States Supreme Court case. And basically what that says is school officials require reasonable suspicion before searching. So the question is the SRO acting on behalf of the school as a school official? In that case, reasonable suspicion for a search is required. Okay? Or is the SRO acting as a police officer for the purpose of following up on a criminal investigation? Now, when we're talking about guns, chances are the SRO is going to be a police officer and not a school official, right? Regardless, we're talking about a frisk, right? Frisking the person, right? A pat down of the external clothing to determine if the person is armed and dangerous. And so you need reasonable suspicion, right? You can also frisk that backpack as long as you have specific articulable facts to believe the person is armed and dangerous. Okay? Terry v. Ohio, the Terry frisk is going to be the recognized exception under which you are operating as an SRO to frisk a subject as long as you have more than a mere hunch, more than a basic, bare bones hunch that the person is armed and dangerous. Articulate that reasonable suspicion to believe the person is armed and dangerous. Take that anonymous tip, truly anonymous tip, right, and corroborate it in some regard. You've got your reasonable suspicion. You're justified in your frisk. In addition, right, never forget the golden rules. The court is going to weigh the governmental interest versus the level of intrusion on an individual's rights. And in this case, we have a significant governmental and societal interest in preventing mass killings, mass murders at schools, right? Versus, the minimal intrusion that a Terry Frisk represents. So never forget that, right? Always keep that in mind. It's a great question. I highly recommend you check out Nevada's Search and Seizure Survival Guide. There is a Nevada-specific search and seizure survival guide, or if you are not in Nevada, check bluetogold.com/store. That has all of our books on it, state-specific or the national book, right? It includes answers just like this and many, many more. Thank you for the question. If you guys have any questions for us, bluetogold.com/show, bluetogold.com/show. We'll get your questions answered. We'll do what we can to help make sure you get it right every time. Until next time, I'm John Wiehn. Take care, be safe, and we'll see you soon.